you have to employ. Let's walk through some of this material. Let's start at the beginning when we're dealing with all of these issues. Let's start with Mark Gooch. We introduced Mark Gooch during opening. We introduced him through various witnesses during the trial. And nothing about what we told you about Mark Gooch is inconsistent with what you heard. You know that Mark Gooch's character matters. There's an instruction about character. You heard the instruction on character. And it says that you can consider character evidence as you do with all others. Well, what's the character evidence in this case that's inescapable to the state? Character evidence is that he is nonviolent. He was raised in a nonviolent family. He was raised in a pacifist environment. He was raised on a dairy farm. He went to a Mennonite school. He knows the Mennonite way. He went to Mennonite church up until the point where he was 17. So we know all about that with Mark Gooch. And what the state's saying to you is that he had to have acted not only inconsistent with that character, but have obliterated that. And we all know that as a general rule, people act usually in conformity with the character, not in contradiction. So keep in mind that character matters, and we start with the proposition that Mark Gooch is a nonviolent person. We prove to you that he's a nonviolent person. And remember that the state had a vehicle available to it procedurally, and that vehicle was rebuttal evidence. Because the state has the burden of proof, the state has the ability to come back after the defense case is concluded and rebut our case and bring you evidence that disagrees with it. And several times during the course of what I'm going to tell you, we're going to emphasize to you that they did not do that. And one of the areas where they did not do that was on character for Mark Gooch. They didn't go and bring some, you know they went to Wisconsin. You heard in the interview that we got somebody over in Wisconsin talking to Sam Gooch right now. You know they're in Wisconsin. You know they know where Mr. Gooch lives, Mr. Jim Gooch. You know that they could have talked to people in the church. They didn't bring you anybody that told you anything different that Mark Gooch is nonviolent. They didn't bring you one person that says Mark Gooch hated those Mennonite suckers. He hated. He had a grudge against them terrible. Not one independent individual known to Mark, went to school with him, member of the church, in the community, that says anything like that whatsoever. Not even. That's the clean slate that you start with. As we work through this, remember not only just the character and the lack of rebuttal about the character, but Mark Gooch has put before you the abject, straightforward, I didn't abduct her, I didn't know her, I didn't kill her. That's what he's told you. And that's what we're dealing with here. And so that should be in consideration as we work through the evidence. The state spent a lot of time on Mr. Gooch's statement about what he told the detective. And remember that the detective had months to plan. Mr. Gooch had no warning that she was coming. She came with a ruse that it was a drug-related investigation, or not investigation, just a random drug test at the base. And how did he respond to all of that? Did he run and hide? Did he engage in concealment? He didn't do any of those things. After he found out what was there, and remember, his initial response, why are we here? Traffic ticket because I'm speeding on my bike? He had no clue. He had no clue. And then he is voluntary, as you see. He is cooperative, as you see. He is polite, as you saw. And the state talked about demeanor. His demeanor is never stressed. His demeanor is never frantic. His demeanor is not exhibiting body language, despite what Detective Nagel looked carefully at his interview. You will not see body language that suggests a tick or a tweak or a twitch or an avoidant look or looking down at his shoes. That doesn't happen. It doesn't happen. He just addresses them completely during the course of that. You know, too, what you should appreciate is the great surprise of the detective was that he volunteered all kinds of things that suggest that he must not have been hiding anything, or why would a person have done that? He uses his card to get gas. He knows he gets carded in and out when he leaves the base. So he knows all of that's a record. He uses his card, he takes pictures, and he buys burgers, he buys gas. He knows that there's a record. All of those things happen. He's using his GPS. He's charting his whole breadcrumb trip to New Mexico clear as a bell. He's not trying to hide any of that. Wouldn't the person that they were going to try to pull off some secretive, covert mission to New Mexico, hide all of those things, pay in cash, not use your cell phone, not show up at those places where you would be visualized? He doesn't do any of those things. He doesn't try to avoid any of those things. It's all inconsistent with the state's suggestion that he's the guy. You know, the only time that Mr. Gooch shows any concern is at the very end of the process of his statement. When he looked at the detective and said, you know, I think I ought to talk to a lawyer. You're trying to pin something on it. That was his word, pin something on it. So at that point, he realized that there was more to this than whether or not he was riding his bike fast or there was a coincidental trip to New Mexico about which he openly talked about. Now, I want to talk about the detective told you that at the time that she came to the base on 4/21, that regardless of what was going down, she was going to arrest him that day. His statement apparently to her was immaterial. So you can decide whether it's immaterial to you or not, and the content of that is immaterial. But think of the leap of faith that's involved in that. You know, what it takes to arrest somebody is a far lower standard of evidence, probable cause, than what it takes to convict somebody, which is beyond a reasonable doubt. So the detective and the state were banking on the fact that they would be able to generate great mounds of evidence between the time of the arrest and the time of this trial. And we're going to show you that failed, that leap of faith was a failure, and that they struck out because of all the things that they did not acquire. So I want to talk about what I have referred to as negative evidence. And I'm going to spend a little time going over that with an overhead for you. Hopefully you get this book. Negative evidence is what we talked about in opening, the absence of evidence that you might think should be available to be used. And so I want to walk through what we consider to be areas that we want you to consider of evidence that is not present. And that includes communications. It includes Sasha Krause's call, the church facility, Sunset Crater site, the person of Sasha Krause, Gooch's call, Gooch's room at the base, and the gun. If you look at all of that, and there's no evidence produced from that, we suggest that cumulatively, that's reasonable doubt. The absence of evidence that should be there, that's not there. Talk about communications. You know that the state had Mr. Gooch's information, searched it all, and they went back as far as 2016, right? 2016. They found no mention of Sasha Krause ever. They found no call from him to her or vice versa at either of their call records. No search history about Sasha Krause, the Mennonite community. It's clear that there has been no establishment whatsoever that he knew her or that she knew him.
Hello?
No Google search of Farmington Mennonite community, none of that occurred. Now, we go more specifically to Sasha Krause's car. Sasha Krause's car was found at the time that she went missing at the church. And at that time, you heard testimony from the detective about the car and what was done or not done to the car. You heard Detective Strang, the lead detective from San Juan County Sheriff's Department, tell you that there was nothing found in the car that was of benefit. Now, they didn't present their lab person, they didn't present their expert person, but he told you that, so we know they have no data in the car that leads to Mr. Gooch. No fibers, no hair, no blood, no Gooch. Nothing that you could connect Mark Sasha Krause's mom. We spent a lot of time talking about the church. Sam talked about the church. He talked about the church. The detective talked about the church. A lot of talking about the church. The number one thing that we take that Mr. Gooch never seen. No eyewitness account of this. What else do we know? Gooch or his car were not actually seen at approximately 7:45. We know that that's the time, 7:45. So not only Gooch was not seen, nobody saw him. Nobody saw his car at 7:45 at the relevant area. No prints in the church. Remember how the money box was dusted all over the effort to try to find fingerprints. No fingerprints, no DNA, no fibers, no hair, no blood, no disturbance. Gooch. So, two crucial areas where evidence would be important to be found. Objective forensic evidence. There is none. Sunset Crater site. Sunset Crater site is an important place. Oh, you understand? So we start with the proposition of no eyewitness. Which car is not seen there at any point in time. No prints, no shoes, no car, no DNA, no trash, no possessions that links to Gooch. Negative evidence. Evidence where you would had a print, had something that linked to Gooch. First, that's that. Know that there was no found on the person. Fibers. No hair that related to no evidence of sexual assault. Bond or the clothing that she was wearing. Mr. Gooch. Again, a thorough look at all of that was important. Gooch's car, the state's going to question, well, he cleaned his car. Well, the question is whether that was coincidental or purposeful. You'll decide that. But we know no prints, no hair. We stop at the hair. There was a hair found, but it wasn't tested. It's unfortunate. No blood, no DNA, no fibers, nothing from SK, no cinders, no vegetative growth that would relate to anything that tied him to the scene or to the crime. We didn't hear much about the search of Gooch's Airforce base room. And you didn't hear much about it because there was nothing there that related to the case. Nothing from SK, nothing from Farmington Mennonite community, nothing from his room. Just left it out. But that's what you can take from it. They, of course, examined the gun. We're going to talk a lot about the gun here in just a few. They examined the gun. No prints, no DNA. Everyone told you about no bullet. I hope everybody caught this.
Mr. Griffin, I'm so sorry to interrupt, but I know it was just passed to me. Some folks are having trouble hearing you when you're not at the microphone.
Oh, I'm sorry. I'll stay there.
I was going to offer a lapel mic if you want it.
Thank you. I'll stay there.
Evidence bullet not from his shells. Who said that? Who said that? Was it from Ms. Pelosa? Heck no, wasn't from Ms. Pelosa, because we didn't get anything from Ms. Pelosa. What did Mr. Warren tell you that was so crucial, and it came about in such a great way, and I'm not sure that it landed on everybody. Appreciate this. The evidence bullet, the smashed bullet, the damaged bullet, the recovered bullet from the autopsy did not come from the seized ammunition when the gun was recovered. Holy smoke. Why didn't we hear about that from the state? We focused all our time on the gun, and we almost blew by the bullet. The bullet doesn't match the ammo, guys. It's unrebutted, undisputed, and it is absolutely, positively, reasonable doubt number one. Doesn't fit. Huge that it came up through a juror question. Talk about other things that don't fit for a moment. In addition to the fact that the evidence bullet comes from the wrong ammo, let's talk about for a moment the early part of the case, weeks ago, when the mystery white car was tried to be avoided by the state and didn't want to be discussed by the state and had to be pulled out by the defense of the various witnesses. The white car, remember the white car? Did the white car appear, and we'll call it the right time? Did it appear at the material time? What do we know about the timestamp? Was it 7:40, right on the white car? And how does it come up not only at the right time, but at the right place? We get it speeding, leaving, exiting, right past the camera, picture taken, brakes hit, avoidant behavior, lights off. White car, to any reasonable person's position or perspective, had to be suspicious as hell. Who wasn't it suspicious to? Because it does not fit Detective Stang. He couldn't concede suspicion if it bit him. And you know it. You saw the struggle, you saw the dance, you saw the dodgeball. He couldn't do it. But why is that important? Not only the right place at the right time and suspicious and confirmed by video, it was confirmed by how many different witnesses? Not just one, but two. Two different witnesses saw that car. And again, when we talk about the right place, going by the Gingrich house at a time when other vehicles are up at the church. And remember, that's not just nothing, that's something. What's at the church? Sasha's car and Sam Coon's car. So crime is over. Those cars wouldn't be there, and Sam Coon wouldn't have walked through the church, and Juanita wouldn't have walked through the church if there was still trouble. So we know that the confluence of Sasha's car and Sam Coon's car means crime's completed, and what's scooting out of the way at the time? The white car. And who has absolutely, positively nothing to do with the white car? That man. Because his car's blue, and his car was only seen at 4:15, 2 hours off from when he thought it was, as he drove by. That's the only thing that ties his car to this. Wrong time for him. Right time for the white car that they don't want to talk about. It's reasonable doubt in this case. Cell phone tower and dishman. Let's spend some time on that. I don't know about you. I try to avoid things. You gotta stay here. I avoid things that have warnings, or I try to pay attention to warnings. And lots of things we deal with in everyday life have warnings. You all know that. But Mr. Dishman straight up told you that the most important thing, the first thing that you get when you get NILOS data, comes with a warning. The warning is do not use for location. And then we use it for absolutely location. Location, location, location. But it's not supposed to be used for location because it's not precise enough to be able to do that. It's used properly for propagation to help the phone companies determine where they need to put towers in order to give you clean and good cell reception. He then tells us that, well, yeah, there are lots of flyers. Those are the anomalies. Those are things where they get a hit on a tower that's wrong, but because it doesn't fit within their matrix, within their filter, they ignore it. So we know that not only does it come with a warning, it comes with problems, and he acknowledged here that there was bunches of flyers here that affect the credibility of that material. He likened it to, and I asked him about this specifically, is it precision location stuff or is it breadcrumb? And he basically said, look, it's breadcrumb. It tells you the route. He told you the route. He told it to the detective when he met with her. Gave him the route. The route corresponded to what Dishman said. Dishman said, there's caution that needs to be exercised. Because when you see the blob, or you see the pattern that's put on the exhibit, what it was clarified to you. I mean, that's where the cell tower is getting the ping. That just says general facility, and general vicinity. It doesn't mean that that's where the person is. It just means general vicinity. And you talk about, well, this radius of 25 meters or 200 meters. And then you say to him, but wait a minute, what does that tell you about where the person with the phone might actually be? He says, oh, a couple of miles, mile and a half. It has nothing to do with the general vicinity discussion. It's misleading to look at those blobs and think that that's exactly right where a person is. That's exceedingly important when there is the mapping of two cell phones leaving the Farmington area. Mr. Gooch's route we know, which is the route that he took coming in and going out, same route. But we don't know hers because we don't have any active data that gives you any precise location, beyond. We got general route for Gooch, but we don't even have that for her. All we can say is that her phone was in that gigantic area of Arizona-New Mexico border. General vicinity is all that establishes. It's not precise. And remember the final thing that Dishman clarified. The final thing that Dishman clarified was that even if you can get general vicinity, breadcrumb location, you do not get what the activity is. And that's when I made that absurd statement to him about, well, you can buy a burger, but you don't know whether you ate it. The point was, you can't tell us what went down at any location. You can't tell us. And he acknowledged that. So that's where all of the forensic information, the negative evidence information comes in. The state's talked a lot about motive. And the instruction's interesting because it doesn't talk about motive. It talks about, and the state didn't say this, but it talks about motive, and I'm quoting, or the lack of motive. Lack of motive is just as important as motive. The state's worked hard to try to suggest to you that there is motive in this case because of two text message scenarios over a 4-year period that have some relationship to a Mennonite topic. Wouldn't you think it would be just the opposite? That there would be bunches and bunches and bunches of references to Mennonites and hating Mennonites and spewing vile and making plans if that was the intent here. That's not the situation. The situation is that there are two explainable situations regarding reference to Mennonites that the state has stretched beyond capacity to try to establish motive because there's no connection between Sasha and Mr. Gooch. So the first one is, as you know, so again, just to clarify, Mennonite is not a common topic, and indeed not a topic at all, essentially, during the 4-year period, only 2 times. So let's talk about Sunday surveillance on October 12th. We had to point out that that's a Sunday. We had to point out that that's normally the time for when Mennonite church activity goes. And so Mr. Gooch told the detective that he still had interest in attending Mennonite and having fellowship with Mennonite communities. He told her a couple of different places. Do you remember Wickenburg, Scottsdale? Remember the concept of rebuttal? Did you hear the state come back and tell you that there weren't Mennonite communities in Wickenburg or Scottsdale? No. I mean, he's right on that stuff. And he's looking for churches. And he's lonely out in Arizona. And he's looking for fellowship. And so, is he looking for an elderly populated church that's not happening the way he would like to have some young people? No. And he makes a statement about it's not lively here, essentially. That's the expression that he's using. It's older people. It's not what I'm looking for. Well, of course, he's just checking it out. If he had said, I'm checking out the people that are attending the church here, instead of using the word surveillance, I think everybody would feel a lot differently. But the words are interchangeable. It's Sunday morning, that's what he's doing. And he told the detective he's been doing that, and there's nobody that's rebutting that in any way whatsoever. The second only other reference out of 4 years of looking at all this data is the traffic ticket bravado. Bunch of boys talking tough about being stupid and saying offending things. I don't know about you. I suspect many of us have said stuff over the phone to our buddies, to our pals, the wrong time at the wrong place that we probably, if it was posted up on a billboard somewhere, would horribly regret. But it doesn't mean that that's motive to kill. So careful of how we take things out of context. This is the stuff that, by the way, that the instruction comes in about you can prove with clear and convincing evidence. This is an other act evidence. So just be aware that that's what this is about. But this is the stretched effort by the state to demonstrate motive. But there are no threats ever. There's no manifesto ever. There are no plans ever. There's nothing that you would think that if this was going down, that there would have been talk about. There's none of that. Again, it's evidence that's missing. So we're now to ballistics, all right? If you don't know this, I suspect you've probably figured it out by now, but virtually nothing that lawyers who do what we do is accidental. Everything we do, how we present things, is tactical. We are schooled in primacy and repetitive things and how to make and emphasize points. And some do it better than others. But one of the things that we know is that we present a case to you in a fashion and in a form that not only makes sense, but that will have impact. AKA, we save the best for last. Who's the state's last witness? Who's their coup de grace? Who's going to dot the I and cross the T for the state and bring this case all together? Who's going to do what we talked about? We arrested, and we had a leap of faith that we were going to be able to bring this home. We're going to be able to prove this beyond a reasonable doubt. Lisa Pelosa. Lisa Pelosa is their star witness. She's their last witness, and she's their greatest failure. Let's talk about Warren. He tells you it's not a match, and I'll get more specifically into that. He tilts toward exclusion, insufficient stria. You never even heard about that word from Lisa Pelosa. Whose presentation was more clear? I'll let you decide. Whose experience seemed to suggest a command of the authority? Whose knowledge seemed to be second to none? Whose effort seemed to be greater? How many test fires? How many different things? The reasons why he did it? The number of hours he invested? 6 times greater than hers? Who was careful and who was thorough? I'll let you decide. Remember, the state talked about credibility. Let's talk for a second. Ms. Pelosa tells you it's a match, can't say why, can't demonstrate with any documentation whatsoever, no exhibits, and let's talk about credibility. Man, what a train wreck. Hide the ball, everybody's problem except mine. I asked her in her interview, anybody ever disagree with you? And she tells me flat no. Unqualified, unequivocal, no. Nobody disagrees with me. I'm Lisa Pelosa. I'm 22 years of experience. Well, I go digging around. I hang out with other lawyers. I go digging around and find out that's absolutely not true. I absolutely knew about it, the Merritt case, the freeway shooter case, what a big deal that was, and what a similar train wreck occurred there that occurred here. Two different preeminent expert situations, opinions, absolutely inconsistent with hers. Absolutely inconsistent. That case gets dismissed. Okay? And so what does she say? I ask her, tell me somebody that's preeminent in your area. Tell me somebody that's authoritative in your area. Tell me somebody who's an all-star. She tells me Luke Hague. Luke Hague is the one that disagreed with her in Merritt. Luke Hague. And then she tries to backpedal and say, well, he's old. And, he probably doesn't spend a lot of time on the microscope. And that alcohol, tobacco, and firearms guy, yeah, he's good, but they didn't spend a lot of time on this case. Who didn't spend a lot of time on this case? Lisa Pelosi didn't spend a lot of time on this case. So their star witness has credibility problems big time. Her effort, 2.5 hours? I know it when I see it. Got it. I'm done. What did she test fire? She didn't even test fire the seized ammunition. Test fires her own because it's easier and she can get it done more quickly. Thorough, professional? Absolutely not. But what does she miss that we already now know? She doesn't even know anything about the evidence bullet. She doesn't tell you anything about the evidence bullet because she never even tried. She didn't care. Because she's only focused on the gun. And she missed this gigantic iceberg of a piece of evidence. Warren didn't miss it. So, is it reasonable doubt that the evidence that was seized from Gooch is not the evidence that resulted in a bullet that killed Sasha Krause? It's a huge issue. You know it. And you also know that the gun doesn't match. Now, counsel's quick to point out, well, that doesn't mean it can be completely excluded. But unrebutted, no rebuttal here, millions of Marlins, guys, millions of Marlins. But there's no effort here to do any better than that. So all we can tell you is, you can look at the exhibits, we brought them to you. If you could match up the evidence bullet with any test fire, you're Lisa Pelosi. Reasonable doubt is established by the bullet not connecting to this case from the evidence that was seized, and that the gun cannot be taken as the weapon that made this shot. That's so important because, again, the leap of faith that was taken by the state that somehow, some way, they would present to you objective forensic evidence linking Gooch to this crime. And they cannot, and they have not. I want to talk last and finally about the burden of proof. The burden of proof is what we all swore that we'd adhere to here under a couple of different oaths through exhaustive qualification process, jury selection process, and you all swore that you would do your duty and adhere to the rules that we require. Sometimes, saying a concept is easy and comprehending it perhaps more difficult. This chart is intended to try to show you how you hike up the mountain of burden of proof. And I was thinking about it today when I was driving up from the road. I was thinking about, if I was going to do a hike, it'd be worthy that I hiked Cathedral Rock in Sonoma. That's a good hike, not a hard hike. But that's about here. It would be worthy if I came to Flagstaff and say, I can do more. I can do bigger hike. I can do Mount Eldon. That's a pretty good hike. That's about 9,000. That's a pretty good hike. Maybe reasonable doubt is a bigger burden than that. It's a higher climb than that. It's like climbing Humphreys. Climbing the peaks. It's like doing the hard climb. That you've got to get all the way up there and take it from burden of proof being presumptively innocent to absolutely eliminating all reasonable doubt. So how far did the state hike in this case? And whether or not they encountered obstacles along the way that they've been able to eliminate. Does the bullet matter? You decide. But the definition of reasonable doubt doesn't say how many you have to have. It just says that if there's reasonable doubt. Doubt that is established by reason from the evidence. Bullet's reasonable doubt. The problem with the rifle, that the rifle doesn't match, that creates reasonable doubt. Why would it have been otherwise? The state would not have put so much effort into showing. Why would the state have done all of the work they did, all of the laboratory people that they brought you, 4 or 5 different experts, additional detectives, and every time that they marched them in, you had to be holding your breath each time going, I wonder whether they're going to deliver with this expert. Deliver some connection to Mark Gooch. And you could feel the room, the air go out of the room. You could feel it. Because when Aaron showed up, or Miss Lowe showed up, or Mr. McLean showed up, or any other expert that you want to identify, I asked Aaron, how many times do you show up to tell us you don't got it? He said, a lot. And that's what you got here. Repetitive don't got it's. Can't deliver any connection forensically and objectively to Mark Gooch. So that's your dilemma. That's your burden. Burden has been presenting this case in front of these difficult circumstances. The burden is now yours to decide how you're going to deal with established reasonable doubt, lack of objective forensic evidence linking Mr. Gooch to the crime, in the sea of circumstantial stuff that the state has presented. How do you, as the representatives of our community, in a case as important and as significant as this, how do you decide, whether you're going to hold your duty and understand reasonable doubt, or how you're not? At the end of the day, what we're asking you to do is to do your duty. Don't allow a miscarriage to occur. Don't allow reasonable doubt to be ignored when it has been established. Don't allow emotion to cloud your judgment. We're asking you politely, but firmly, and with the understandable difficulty that it will take, to do your job. And find in our system, not whether you think maybe he did it, or possibly he could have done it, but whether or not it's been proved beyond a reasonable doubt, or whether or not the defense has produced numerous reasonable doubts, collectively, individually, whether that's been done. That's now your burden to make that decision. When you exercise all of your
common sense, your collective wisdom, and you do your job, you'll have to conclude not whether he is absolutely guilty, or however you want to define it, but whether the case has been proven or not beyond a reasonable doubt. This case has reasonable doubt and has not been proven to that level of requirement. We didn't get to Mount Humphreys here. And you must return a verdict of not guilty because the case has not been proven. No tape, no evidence of fingerprints on any of that kind of material. None of that could be linked to Mr. Gooch. That's the problem. All of that's missing.
Thank you, Mr. Griffin. Counsel, you approach